Good morning. Can I welcome everyone to this, the 25th meeting of the Justice Committee in 2012. Can I ask everyone to switch off mobile phones and other electronic devices completely as they interfere with the broadcasting system, even when switched to silent. Due to Hamza Yousaf taking up ministerial office, I welcome Gordon MacDonald appearing as his substitute. I'm sure we would want to congratulate Hamza. I shall miss his charm, or perhaps it's his youthful cheek. I think the jury's out, but I wish him well. I'm sure we do in his latest escapade. I'll call it an escapade. Item 1, decision on taking business in private. We're invited to agree whether to consider item 3 in the committee's work programme in private. Is the committee agreed? We're agreed? Agreed. Crumbs. Right, well, there we go. Could I ask the witnesses then to come and take their places, and we'll move on to the next item on the agenda? No, I'll just go straight on. You told me I didn't have them at the table. We were going to have a discussion. That's why I didn't. Can I welcome Elspeth Molony, Senior Policy and Consultancy Manager at Capability Scotland, James Wolffe, QC, Faculty of Advocates, Mark HARROWER, the Vice President of the Edinburgh Bar Association, Oliver Adair, Legal Aid Convener, and Ian Moore, Legal Aid Vice Convener at the Law Society of Scotland. Welcome you all, and I thank you all for your written submissions. And we are looking primarily at part 2 of the bill, but later on, if somebody feels they want to say something about part 1, please do not feel constricted. Can I ask for questions, please? Alison?
Good morning, panel. Does the panel agree with me that access to justice, fairness and proportionality should underpin these new arrangements? We've received quite a number of representations that the proposed arrangements don't live up to those criteria. For example, those acquitted on appeal will have to carry the costs, and those acquitted would have to carry the costs. The appeals arrangements are rather strange. Would the panel like to explore those particular issues?
Please just self-nominate, and I'll call you, and your microphone will come on automatically. So who would like to start? Mr. Adair, Mr. Moore first. Yes, Mr. Moore. Good morning.
Good morning, and thank you for the opportunity for attending today to explain some of the concerns that we do have along the lines expressed by the committee already. The consultation document stressed at page 6 that there was a commitment to maintaining and improving access to justice, and that in addition lawyers should be paid fairly for the delivery of a good quality service. And there are a number of concerns about all aspects of what the bill seeks to do, which lead us to conclude that it's not going to achieve those aims in its current form. Largely, the reasons for that are the levels at which contributions will start, how high the contributions go, and the fact that solicitors will be asked to collect summary contributions, all of which we see as creating substantial problems for access to justice.
Does anybody else want to come in?
We would absolutely agree that access to justice should underpin the bill. We carried out an extensive programme of research at Capability Scotland in 2009 on behalf of the Justice Disability Steering Group, which is a group of justice organisations, including the Law Society of Scotland, the Scottish Legal Aid Board and the Scottish Government Justice Directorate. And we found that 40% of disabled people said that they didn't feel that they had equal access to justice compared to non-disabled people. So we're operating at a starting point of disabled people already feeling disadvantaged, and we would urge that the bill must ensure that that situation isn't worsened.
Is it going to make it worse?
We believe so, yes.
Could you expand? I think that's what...
Yes, absolutely. The latest poverty statistics released by the Scottish Government show that disabled people are disproportionately likely to be living in poverty. 25% of disabled Scots subsist on less than £10,000 a year, and households including a disabled person are 20% more likely to be living on a net annual household income of £0 to £6,000 per year. Therefore, it's likely to mean that many disabled people who previously qualified for criminal legal aid will now actually be asked to make a financial contribution to the cost. And we're operating also in an environment where poverty amongst disabled people is actually likely to worsen as a result of welfare reform. The next 5 years will see a 20% cut in disability benefits as disability living allowance is replaced by personal independence payments, or PIP. And all disabled people will be reassessed to their eligibility for this benefit. So these cuts are likely to mean that 360,000 disabled people will not receive any financial contribution towards the additional costs of living with disability.
Of course. Is it not the case that the disability living allowance will not be discounted and will actually be taken into account? And do you think that that's fair?
Well, no, we don't. We feel that disability living allowance, or PIP as it will be replaced, should be completely disregarded in income calculations. But it's also important to note that disregarding disability benefits isn't actually the end of the story for disabled people, because disability benefits don't cover the totality of the costs associated with living with disability. The DWP itself admits that. The Department for Work and Pensions carried out research in 2005, and they found that the extra costs incurred by disabled people range from £7.24 per week to £1,513 per week. So there's general consensus that disability benefits do not cover the entirety of a person's costs, and therefore just disregarding disability living allowance is just the first step. The second step is to calculate a person's disability-related expenditure and then subtract that from the disposable income calculation in order to make sure that disabled people aren't at a disadvantage.
Does anybody want to pick up on, I know that I'm giving you the chance to come back and say, you know, solicitors always moan about having to do things and everybody has perceptions that that's all you do. Why shouldn't you collect the payments, the instalment payments?
Please, Convener.
Yes, you can, Mr Harrower.
Thank you very much for allowing me the chance to give evidence to the committee today. I'm speaking for the Edinburgh Bar Association, which is the second largest faculty of solicitors in Scotland. I'm also speaking today on behalf of the GBA, the largest faculty of solicitors in Scotland, because we both come together in our opposition to the proposals contained in this bill as they presently stand. It's the Glasgow Bar Association, yes, as well.
For anyone else.
Thank you. At the moment, solicitors have a relationship with accused persons, which is an important one, and it's a close one. And it's been very important in implementing the improvements in early case resolution brought in by, which were the aims of summary justice reform brought in about 2008. And the improvements have seen a steep increase in the number of cases which are resolved early. And that's brought about a lot of savings. Now, we have a close relationship with our clients because they have to accept the advice we give them at an early stage. As a result of SGR changes, we now get a summary of the evidence from the Crown at the start of a case, and we go over that summary of evidence with accused persons. We give them advice. And very often they accept that advice and the cases can be resolved early. Now, to ask us to collect contributions which will be far in excess of any contributions which are in place at the moment, and I'll come back to that in a minute, will place a layer of conflict between us and the people that we represent in court. And there will be many stages in cases from now on, if these changes come in, where we will be giving advice to an accused person at the same time as asking them for money, asking them for contributions, which will be quite large. We foresee delays resulting as a result of this, because contributions won't be paid. We foresee clients falling out with our solicitors because contributions haven't been paid. I mean, as solicitors, we have no mechanism of collecting contributions like this. At the moment, the levels of contributions which we are expected to collect and which SLAB accepted way back in 2004, most solicitors don't collect, are pretty small, and proportionally, I think, amount to about less than 1% of most firms' annual turnover. For example, at the moment, contributions from clients relate only to advice and assistance, and ABWAR cases, which are cases which result in an early plea of guilty at the start, or certain cases where there are breaches of court orders for people already convicted of cases. That's what ABWOR cover is. And for example, disposable income starts at the moment at £105 per week, and if you have a disposable income of more than £105 but not more than £112, at the moment the maximum contribution is £7. Now, under these proposals, for a sheriff court summary case, which is the most common type of case at the moment, an ABWOR contribution for someone pleading guilty will be £134, but if you plead not guilty in the sheriff court, your contribution will be more than that. In fact, it will be £145.60. There's actually an anomaly here, just as a side issue, that it would seem to us that if you plead guilty in the sheriff court, you actually pay less of a contribution than if you plead not guilty. So there seems to be a financial disincentive to people to plead not guilty and exercise their right to plead not guilty. But quite apart from that, at the moment, the contributions go from £7 up to a maximum of £135 for A&E and ABWOR cases. There are no contributions in cases where people plead not guilty. Under the proposals, if you have a disposable income of around about £160, your contribution will be more than the fixed fee as it stands at the moment, which is £485. Now, we will have no mechanism of collecting that other than asking people to pay us. In the Herald last week, it was reported that there are still £6.5 million worth of fines owed to the courts. And the Scottish Court Service have powers like enforcement actions, including benefit deductions, freezing bank accounts, stopping wages and seizing cars. We can't do any of that. The Legal Aid Board, in their consultation leading up to this bill, told the government they didn't need any additional powers to recover contributions because they had been successful in doing so in relation to civil cases. And it has to be remembered that the SLAB collect contributions in all civil legal aid cases. They say they will collect contributions in all solemn criminal cases, but they refuse to do so. They say we should do that in summary criminal cases. And the reason for that is that they know that we won't be able to do that in a lot of cases, and it will be a cut for us. It will simply be a cut. Now, why shouldn't we collect these contributions? Well, when we are doing a difficult job, and it is a difficult job, and we are trying to do our best to make the system work, which solicitors in Scotland do, asking us to collect contributions will create another conflict between us and the client, which will lead to further delays, it will lead to cuts for us, and it simply won't work.
I'm going to bring another, so just on contributions, because I think, Jenny, you come in something else. Different. And I think, apart from everything else you said, one of the things that struck me is you are saying that because of this system coming in, it will interfere with justice.
I mean, let's look at a couple of specific examples. Let's say we've got to an intermediate diet, which is 4 weeks before the trial. An accused person accused of a sexual offence has pled not guilty. And it can be quite a serious sexual offence, notwithstanding the fact it's on a summary case. Somewhere in the consultation documents it said that these are not serious cases. Summary criminal cases in the sheriff courts are more serious now than they've ever been. When I started in this job 20 years ago, for breach of the peace and a summary complaint in the sheriff court, you could get up to 3 months imprisonment. If you're on bail at the time, you could get an additional up to 3 months imprisonment. That's a total of 6 months. Now, if you're accused of breach of the peace, exactly the same charge, you can get up to 12 months imprisonment on a summary complaint. If you're on bail, you can get an additional 6 months. That's a maximum of 18 months imprisonment. But it's not just bail that aggravates these things. It's racial aggravations, it's homophobic aggravations, and ASBOs. It's far more complicated, it's far more serious. I'm doing a case at the moment, a summary complaint, which on another day 10 years ago would have been an assault with intent to rape, and would never have been seen in a summary complaint. And you can ask solicitors up and down in Scotland and sheriffs who frequently comment on it. Summary cases have never been as serious as they are now. So you've got people coming to court for cases which are serious, including, say, a sexual case. If we get to the intermediate diet, and this accused person has to pay a contribution of, say, £200, and he's not paid a penny piece, and we're 4 weeks away from a trial diet where there are vulnerable witnesses or child witnesses, the solicitor will say to the sheriff, the contribution has not yet been paid, I'm not ready to go. What is going to happen? Now, the policy memoranda are silent on this. In fact, they actually say they don't know what's going to happen. If I can quote from the SPICE document, it says in page 24, page 24, convener.
Page 24, thank you.
Under the heading Practical Implications, at the last paragraph, it says that it is unclear what options a solicitor might have when dealing with a client who does not make payments as required. It goes on to say it may be possible for solicitors to withdraw their services in less serious cases. Now, I don't know what they mean by less serious cases. And neither do they, because they go on to say it is not clear where the dividing line between less and more serious cases might lie. Now, from experience, we now frequently deal with summary complaints which involve embezzlements of £20,000 plus, DSS frauds of £40,000 plus, assault to severe injury, serious sexual cases, as I've already mentioned, cases which frequently involved forensic evidence, scientific evidence, CCTV evidence. These are complicated, serious cases. Now, if we get to an intermediate diet and someone is not paid half of the fixed fee as a contribution, then solicitors will have no option but to say, we're not ready here, and we haven't had this paid. Now, what will happen to the legal aid certificate? SLAB, at the moment, in civil cases, suspend a certificate for 30 days, and if the arrears aren't brought up to date, then the certificate's terminated and the case effectively comes to an end. But civil procedure is completely different to criminal procedure. In the criminal courts, the case must go on. The accused is not a willing participant in it. He's not a pursuer who stepped into court to sue to get some remedy. He has been brought into court by the state. And if an accused is on remand, then the time limit's 40 days. And not all people who are in custody will be exempt from contributions because they may have savings of more than £750, which is going to be the limit if these changes come in. And if it's a domestic abuse case, then it's got to be 8 weeks between the first plea and the trial, whereas some of the timelines for recovery of contributions are 26 weeks in the policy documents. So by 8 weeks, only a fraction of the contribution will be paid if these come in. So what's a solicitor to do at the intermediate diet in a domestic abuse case, which is after, say, 6 weeks? Hardly any of the contribution will be paid. We'll have to say, we are not ready, because we're not sure if we're going to be paid for this.
And can I, because there's an issue I raised, can you also perhaps touch on when there's a co-accused? I mean, that would complicate things.
Well,
further,
it would
surely.
do. I mean, when there are co-accused, every accused has to be ready for the trial. And you can have so many cases with 4 or 5 accused commonly. And if not every accused is ready, then there will be a delay. The court will have to grant an adjournment. And if we get to the stage where the contribution the accused person has refused to pay the contribution repeatedly, what's the solicitor to do? You'll have to withdraw from acting. It makes it very difficult for solicitors to balance their professional responsibilities to the court to make cases work and to keep cases going, and to the client to represent them, when at the same time they're not being paid for the work they're doing.
Can I move on to others who want to come in on this? I know who've also been in practice at some still in practice. Rod, then David, and then Alice. Are you back on this again, or?
Well, if I might, convener, just hear on the general principles from the Faculty of Advocates before we go into the detail.
I didn't know you were indicating that you wished to come in the general principles. My apologies, Mr. Wood.
Not at all, convener, and thank you very much for inviting me to give evidence today. On the general principles, I entirely endorse the view that the 3 principles of access to justice, fairness and proportionality must be tests by which any proposal of this sort is measured. But can I add to those 3 the question of the impact on the administration of justice, and if I might endorse the remarks that Mr. Harrower has just made about the potential impact on the smooth running of the courts, and add as an additional point, which is made equally well in the Edinburgh Bar Association's written submission, that these proposals, if brought in, one might expect to result in an increase in accused persons representing themselves. Now, that is likely to have, for the reasons set out in the Edinburgh Bar Association's written submissions, a significant impact on the smooth administration of justice, and may result in unfairness so far as particular individuals are concerned. As you know from the faculty's, as it were, big point on this is a really fundamental one about fairness, which is that it seems to us basically to be unfair that someone who is brought into court on a criminal charge is not ultimately convicted for whatever reason, may nevertheless be left to bear the cost or a part of the cost of his or her defence. And it seems to us that not only is that simply unfair, but is liable to lead to what may fairly be called perverse incentives of the sort we describe in our written submission. The other point in terms of fairness is, of course, that any system of contributions which starts from the premise that you have people who are able to meet part of the cost of their defence should be designed in a way that it only bears upon people who really can afford to meet the cost of their representation. And I would respectfully align myself with the observations made by the Law Society of Scotland and the Edinburgh Bar Association in their written submissions in that respect.
Thank you. Thank you very much. And David. Sorry, Rod first, then David.
I refer to my register of interest as a member of the Advocates. And Mr. Harrow, or anybody else on the panel might be able to help. I just wanted to touch briefly on the question of ABWAR and contributions. As I understand it, maximum contribution 135, approximately 43,000 grants of ABWAR in the last year and £20 million spent. Presumably that 20 million is exclusive of contributions. Do we have kind of more information on how much was raised by contribution and what precisely are the levels of non-contribution? I know you talked about some of the contributions being only £5 or £6. It would be helpful to put some more teeth on the issue at the present time.
At the moment, my firm do not collect contributions. The reason for that is we don't have time to do it. We don't have the mechanisms in place to do it. And we don't want to create a conflict. It's not worth creating a conflict between ourselves and the client with the current level of contributions in place. I'm not sure how much contributions should be raising. SLAB would be the best place to tell you that. But SLAB know, and have known since 2004 when they commented on Sheriff McInnes's proposals for review of the whole summary criminal justice system, they knew that most solicitors did not collect. And in fact, in 2004, SLAB proposed that contributions should be removed completely. I think SLAB implicitly realised that contributions and the issue of their collection potentially could raise another area of difficulty between solicitors and the accused, where this was an important relationship which was central to the early resolution of cases. Now, the proposals suggest that contributions should be increased to a rate where they're just about the whole fixed fee. The most common fixed fee put in by solicitors is £485. That's for cases which plead guilty at the outset in the Sheriff Court on a summary complaint, but also cases which have had a not guilty plea tendered at the outset but don't go to trial. Therefore, there's a guilty plea later on in the procedure, and the case has gone to trial, but it hasn't gone over 30 minutes of trial. So 485 is the most common figure that is feed by solicitors. And as soon as you have a disposable income of around about £160, you'll be paying the whole fixed fee. In other words, solicitors will be having to collect the whole fixed fee. And we'll be having to do that before the conclusion of the case to be sure of getting paid it. As far as how much contributions inject into individual firms at the moment, I really can't say. It doesn't inject anything into ours.
Just coming back slightly on the contribution level, according to the government's figures, income and capital together would, on ABWAR, would only come to 330. The average contribution from, I think, the 18 or 20% of people contributing. So did you take issue with the government's figures in the financial memorandum?
Perhaps I can assist there. The 20% figure that's mentioned is a figure we assume given to the government by the boards. Part of the difficulty is that we have never seen any data to support those percentage figures, so I don't think you can take them at face value as utterly accurate.
Else commenting there, David? Come in on the contributions and so on.
Yes, good morning. I wonder if we could put just some numbers on the cases that we're considering here. How many cases fall into the criminal legal aid category where effectively responsibility for contribution collection is going back to the solicitors, along with ABWA?
According to the SLAB annual report of 2010-2011, there were 153,962 grants. 153,962.
152,962.
153,962.
Sorry, beg pardon. Right, and how does that compare with a sort of the totality of cases?
That's the total figure for criminal legal assistance, and 27% first 2,000 were ABWA.
27,000 were ABWA. Right, and then what about the ones that are currently assessed and collected by the Legal Aid Board? What proportion is that?
They don't collect any criminal contributions at the moment. They collect civil contributions at the moment. And
Sorry, beg your pardon.
They propose to collect solemn criminal contributions, and we think that's because the last thing SLAB want is for a High Court judge to be ordering them to turn up at the High Court when a High Court case grinds to a halt due to an unpaid contribution of £200. But they're quite happy for that to fall to us in the summary criminal field. On the default rates, I think Mr Campbell raised this in our written submissions at page 7. We repeat what was said in the SPICE briefing report, where it's accepted that there will be non-payment of contributions. It's accepted that there will be a loss. And the figures put on it are up to 30% non-payment in only 18% of cases. SLAB say that in 18% of cases there will be a contribution to be paid. And it's accepted, I think the Law Society estimated that up to 30% of this 18% of cases would result in non-payment of the contribution. SLAB think it's rather less than that. We, the Bar Association, think it'll be more than that, because if you look at, again, at the Herald article last week, of fiscal direct penalties, 2 million in arrears for 2011-2012. That's 42.1% of the total value of fiscal direct penalties are still outstanding. Now, we think 30% non-payment in the 18% of cases where there's going to be a contribution is low. SLAB say it's too high. But in any event, there's going to be a significant proportion of cases where people are just not going to pay, and we're expected to take that hit, to call it that.
Could I, in the government's consultation, it said that requiring solicitors to collect contributions in relation to ABWA, whilst SLAB collected contributions in relation to criminal legal aid, could create a perverse incentive for solicitors to encourage clients to plead not guilty to be relieved of the burden associated with collection. Is there any evidence to support that statement?
I think the evidence is contrary to that, because if you look at the contributions proposed for summary criminal sheriff court cases, the contributions are actually higher if you plead not guilty. I think I've got some figures. If you have a disposable income of £182 per week and you plead guilty at the moment to a sheriff court summary case, your contribution is £77 out of the 485, which is the fee. After these proposals come in, if they come in the present form, your contribution will be £440 of the 485. But if you plead not guilty initially, but resolve your case by way of a guilty plea later on, that doesn't mean you plead guilty to the whole thing. There are many reasons why people resolve their cases later on. Your contribution will be £681.20. If your disposable income is about £161 a week, it's £440, again, if you plead guilty, but £473 if you plead not guilty. So the incentive is actually to plead guilty, and we think that's wrong.
So we can dismiss that on the basis of your evidence anyway. And then can I just refer to the evidence that we got from the Scottish Legal Aid Board, which again is on this issue about incentives. And they say that if the onus of collection were to shift to the board for summary criminal legal aid but remain with the solicitor for ABWA, the latter could become a less attractive form of legal assistance from the solicitor's point of view. And they go on to say, given the shift towards guilty pleas seen when ABWA payments were increased in 2008, there is a risk that any difference in collection responsibilities could lead to a reversal of these advances. The implication that the collection mechanism has an impact upon whether people plead guilty or not guilty.
It will have an impact, but the impact will be to reverse the improvements made by SGR in 2008, because if we also have to worry about getting contributions in before the case is dealt with and the accused is off into the sunset and has waved us goodbye, then we will be more likely to have to seek a continuation without plea before putting in an early guilty plea to make sure that the contribution is at least begun to be paid. I mean, in the policy memorandum, page 19, paragraph 79, it states that consideration was given as to whether the board would require new powers of recovery in order to maximise the potential savings. However, given that the board already collects contributions in civil cases using its existing powers with considerable success, the government concluded that special powers of recovery are not justified. Now, we don't have any powers of recovery. Even the courts, who have powers of recovery, can't do it. How can we possibly do it if we don't have powers of recovery?
Convener, if I might come in at that point as well. The Legal Aid Board have also, according to their website in the last week, brought online an enhanced new system to improve yet further their existing collection procedures. These are procedures we simply cannot afford to bring in, and to say that because we have either written off or collected very small amounts under the previous ABWAR scheme, that we should therefore collect all of these contributions, which are the core function, or one of the core functions of the Legal Aid Board, is to assess and collect contributions. To say that because we have done a little bit of that work for them and written off fees in most cases as a result, that we should therefore collect all of these, doesn't make any logical sense. And there's also a more fundamental difficulty with the bill in its current format, in that people on minimum wage, for example, if the figures as proposed were brought in, would have a contribution in excess of £800 as a maximum contribution under ABWAR, or almost £850 for a summary legal aid case. Now, I don't think anyone would view that as people who can afford to pay making a contribution to legal aid. And that's a very, very real problem, because it's likely to lead to people saying, I can't afford the contribution I'm being asked to pay, so I'm just going to plead guilty without a lawyer. And then they might find themselves in prison, having not realised that that was going to be a consequence of it, disqualified from driving, ordered to resit a driving test, all sorts of things that they may not have understood as a consequence of thinking, I can't afford to pay this contribution, so I'll do it myself. And no doubt Capability Scotland will be very well aware that DLA and war pensions are currently not taken into account to assess figures, but under this new scheme those will be included. And it's all very well to say there will be scope for taking into account somebody's outgoings in the last 7 days, but disabled people, or indeed anyone else, might find themselves housebound, or there may be somebody subjected to a 28-day mental health order who's not incurring their normal outgoings. And so that snapshot will say you should be paying a very large contribution, and somebody who might presently be in that category with an income of £135, if they can't vouch outgoings to the satisfaction of the Legal Aid Board because they're not taking taxis to their physiotherapist or whatever it is that would normally be doing, their contribution would increase from nil under the current scheme to £252.50. And again, that's a concern, that these levels are not in fact bringing in a system whereby people that can afford to pay make a contribution to legal aid. That principle is not contentious for us, but the reality of how it would be brought in here is not going to meet that principle, and that's the real concern.
Yes, Ms. Molony.
I'd just like to follow up on your point that even a disabled person in the best possible situation, so not in a cell awaiting their solicitor arriving, finds it very, very difficult to calculate disability-related expenditure. You know, it's almost impossible actually to calculate. If you consider, for example, a family who have to have their heating on more often, have higher heating bills as a result of perhaps a physical impairment requiring the body temperature to be maintained, or a person who is not able to find work because of discrimination in the employment market and therefore is at home more often and has higher heating bills, or a family with a disabled child who's doubly incontinent and therefore they have far higher laundry bills, right down to a man with cerebral palsy I was speaking to last week who said that he has to buy more shoes than the average person because the way he walks, his shoes get worn out more quickly. For these people to actually try and compare their expenditure on these items with sort of the average household or with non-disabled people, you know, it's incredibly difficult. The gentleman I was speaking to last week about the shoes just said, look, it would just be impossible. So even in the best possible situation, and these aren't the situations that we'd be talking about here when a solicitor is trying to establish what a person's outgoings are in order to establish their disposable income and therefore their contribution. You know, in a stressful sort of crisis situation like that, we believe it would be nigh on impossible for a person to actually give an accurate description of what their outgoings would be.
It is a follow-up, if you, I don't know if this is the case, but certainly in civil legal aid, which I used to do, that if you submitted that to the Legal Aid Board and said, these are the outgoings, these would be challengeable by the board, would they not, as well, whether or not they granted. So there's a lot of administrative stuff would have to go on there, is there not?
It's getting worse. I mean, the board have recently introduced new guidelines where they want to see evidence that we have seen vouching of all the financial documentation pertaining to an accused person. We've got to see bank statements, we've got to see wage slips, we've got to see evidence of certain benefits, and we have to confirm that we've seen all of this or have a very good reason for not having seen it before the board will even consider paying us for the work we've already done. Because it has to be remembered that a lot of cases are dealt with in a very short time frame in the criminal courts, because that's the aim of summary justice, summary criminal business, and we understand that as defence lawyers. Often people can appear from custody and be dealt with in the same day, and they can be off to jail or they can be fined, and we're just starting to make the legal aid application after the case is over and we've gone back to the office. And if we can't get hold of financial documentation after the fact, and don't forget the client has no real incentive to give us it, then we won't get paid.
Need electricity bills, shoe bills, receipts.
That's exactly the position. Every single outgoing that you want taken into account would have to be vouched in writing. And so that's going to cause delays. It will cause churn in courts with continued intermediate diets, adjourned trials, and that will not result in an overall saving in the criminal justice budget if the churn carries on in the way that's anticipated. The whole thrust of summary justice reform has been to try and speed up the resolution of cases through the courts. This will cause the opposite effect in our view. And there's also a legitimate concern raised by the Church of Scotland at page 2 of their response that there may be access to justice problems resulting from solicitors taking the view that it's impossible to carry on doing legal aid work, particularly probably in rural areas where often the solicitor is undertaking legal aid work in order to provide a service to the community and not because it's the most remunerative work that they do by any stretch of the imagination. And that would cause substantial additional difficulties for the operation of rural courts and so on. And really, on a basic principle, a scheme which might incentivise people to plead guilty because the level of contributions has been set wrong simply doesn't provide justice at all, doesn't meet the requirements potentially of ECHR, and it should be borne in mind that the cases we're talking about here are now much more serious because, as Mr Harrower rightly identifies, summary justice reform took a lot of the more minor cases away from court altogether, and they're now dealt with in theory by the person paying a fiscal's fine, but we can see the difficulty with that and the huge level of non-payment. So to suppose that this is going to do anything other than add to those difficulties and undermine the good work that's been done so far in summary justice reform, I think it's not going to achieve that in its current form.
Back to the word current form perhaps later, unless Graham's going to pick up on that. Graham, and then John, and then Jenny.
Thank you. I suppose legal aid is a bit like income tax, that no one volunteers to pay their way when it comes to contributions. And your description of the £7 or thereby of contribution almost takes you back to Dickens' day in terms of the value that might offer to the system. And I understand many of the issues that have been rehearsed this morning in terms of how this might impact on the system. One question I wanted to ask, just to begin to round off some of the ideas I have, where someone is a client and fails to pay their contribution in one specific case, do you foresee that there will need to be some form of directory that indicates that they are a bad debtor, and therefore if they come back to the system again, are they treated in the benefit of not having paid in a previous case and therefore not even being considered for legal aid in a subsequent case, or would it be seen that a client would be treated as a new client on every occasion?
Problems with the system that's proposed, where the solicitor collects the summary, is there will be no central record of whether they're paid or not. So if a client doesn't pay his solicitor, then goes to a new solicitor, that new solicitor will never know that that person has been abusing the system by not paying his contribution.
So would you anticipate that you would want to create such a system, or is it just it sounds bordering on a difficult time. I'm not going to have a third go at that one. Do you see that you would form that kind of administrative support, or would you just give up on it and treat it as...
It would seem to us to be more logical to say that the boards would then select, because they have systems in place to do that. And the selection civil at a 95% success rate. So surely they are the body who select it and have that central record.
Thank you.
Interesting point. And I've got John, and then I'm going to take Jenny, then I'll take Rod. John, on the same issue, contributions, impacts?
Impact on the system, if I may convener.
Is there something like that? You should be waiting a long time.
No, that's not about contributions.
Right, I'll take you on contributions. Yes, if it's contributions to impact to the system, because I had Jenny waiting a long time to come in.
I'm on contributions.
You're on contributions, yeah. Rod? Definitely.
Yes.
Right. Then I'll take Jenny, then I'll take John. Just to make sure you're not slipping something in. Rod, not that you do that.
I'd just like to refer to the policy memorandum again. There's the reference to the fact that if contributions are made, they can be treated by solicitors as payment of fees straight away and improve cash flow. Can I just ask what you think of that as a possible sweetener, and what other steps could the government take to kind of make life easier for practitioners in respect of contributions?
It's fair to say that would be for assistance to the solicitor, surely, that if we can put the money to fees, but of course that only works if the contribution is collected. Otherwise it's of no value whatsoever.
Anything else that the government could do?
Ask that to collect.
I think that's the issue.
That was the universal response from all persons that replied to the consultation, was that these problems should not have to exist because the Legal Aid Board should be asked to collect the contributions. And we haven't heard a compelling argument why that shouldn't be the case. And all of the potential difficulties of churn and delay in court cases, which ultimately are going to increase the overall justice budget, would be taken away by a relatively small amount of money that SLAB would need to add to their budget in order to collect in all of these areas of legal aid rather than simply in civil.
Mr Wolffe, you wish to...
Yes, thank you, Convener. The issue of who collects contributions is an important one, but I wonder if I could invite the committee to not focus on that issue exclusively, because the fundamental issue here, again, with the basic principle that those who can afford to pay may properly be asked to make a contribution, not being an issue. There remains a question about the level of income at which contributions kick in, and whether we're really dealing with people who can afford to make a contribution. And the other point which remains is whether it is fair to have a system where someone who ultimately is not convicted remains bearing what can be very considerable costs. And in that regard, we've talked a lot about the potential impact on the administration of justice and the summary justice system, and it's perhaps there where one can potentially see the most significant problems. But the system of contributions is going to apply also in solemn cases, in the most serious cases which accused persons face, and where accused persons may be faced with a system of contribution with very significant bills for their proper defence, and where one runs into first of all, the issue of perverse incentives, and also the issue of fairness in terms of people facing what can be significant bills, which, even if they're not convicted at the end of the day, they will have to bear.
Rogers.
Just following on what James WOLFFE has just said, not directly on contributions, I presume it's a question you can't answer, but I'd just like to ask it all the same. In terms of privately funded clients at the present time who are acquitted, have you, the faculty, any kind of estimate of what the cost of reimbursing the legal expenses would be?
I'm afraid I can't offer you a cost. I should say that that's the one point which is made in the policy memorandum in response to our position on this, that in effect the current position for someone who doesn't qualify for legal aid at all is that they have to simply bear the cost. Our position on that is that the fundamental unfairness applies equally to those persons. And in fact, what the government's identified is an anomaly in the current arrangements where someone may be put to these costs, not convicted at the end of the day, and be left out of pocket.
I just want to ask you, suggesting there should be an award of expenses? As prevails in the civil court?
Well,
at the discretion of the sheriff? Or at the judge?
Well, in effect, there should be a system whereby somebody who requires to personally contribute to their defence against a criminal charge and who ultimately is not convicted can recover at least an appropriate proportion of the costs. That seems to us to be fundamentally fair. The state has hauled someone into court on a criminal charge, has not made that good, and why should the person who will have been put to a great deal of stress and anxiety, apart from anything else, also be left potentially significantly out of pocket?
If we're to agree to contributions, means-tested contributions, for criminal legal aid for appearances, we shouldn't, are you suggesting we shouldn't touch that unless we also look at the introduction of awards of expenses in criminal proceedings?
Well, we're looking particularly at the issue of contributions and their recovery in the event of an acquittal or no conviction. All I'm saying is that the one answer, the one objection that's put up by in the policy memorandum, which is that currently people who don't qualify for legal aid at all have no system whereby they can recover. It seems to me not to be a good answer. Whether it's necessary to, as it were, go and deal with what we would see as an anomaly there while we're looking at this issue is really another question.
Can I say that if you're moving from a system of modest contributions, which you have at the moment in some cases, to a system where it's not so much contribution as almost full funding or full funding by many people who currently qualify for legal aid, then it's perhaps unjust that in the significant proportion of cases where there is no conviction resulting in summary cases, and we're talking, for example, of about 7% of summary criminal cases in the year 2009-2010 did not result in a conviction. They were either not called or deserted, which means dropped, or a not guilty plea was accepted. And that's not cases which went to trial that year. I don't have figures for how many people were acquitted after trial. That's before we even get to the trial stage. That's a significant number of people go through the courts who are actually found not to be guilty of what they've done. If we're going to ask a lot of these people to pay all of their defence costs, or a significant proportion, then I think we should look at the question of whether they should get a refund if they're acquitted, as they do in England.
Get a refund in England?
If they're acquitted get a refund in England.
Interesting. I'll take Jenny now. It's waited a long time. Then I'll
If you don't mind, that's exactly what I wanted to pick up on. I mean, effectively, this proposal is you still have to pay even if you're found to be innocent, and the process of being brought to court is non-voluntary. So it can't be compared with civil, because you voluntarily enter into a civil legal proceeding and you don't with a criminal prosecution. And I wanted to ask about the other jurisdictions. So you get a refund in England. Do you know about other, if you're acquitted, do you know about other jurisdictions?
I don't know about other jurisdictions, I'm afraid. I mean, other jurisdictions are pointed at by the policy memoranda for other reasons than that, but I don't know about other jurisdictions, just the one over the border.
I wanted to focus my main question. I mean, I think the debate has and will rightly focus around in my opinion, the medieval thresholds of income that the Scottish Government have proposed for these contributions. But can I take you back to the first principles of the contributions in the first place? As legal experts, what impact on our legal system do you think this proposal of criminal contributions will have? And do you think it's correct?
I don't think it's correct. We're talking about savings of 3.9 million per year. Changes which will, I believe, and the GBA and the EBA believe, will cause huge problems for the running of someone in a criminal business if we're to collect and if the contributions at this level come in. I walked past a massive hole in the ground to come here today, which is costing hundreds of millions of pounds. And we're talking about one of the finest legal systems in the world. And we're talking about 3.9 million per year. I think we need to get our priorities right. And I think that whilst people who can afford to pay for their defence at the moment do pay for them, and at the moment the EBA and the GBA accept that there is a level of contribution in place at the moment, has been for years, hasn't changed much for years, we don't really take issue with the levels which are in place at the moment. The levels which are proposed are massive. A massive increase in what's in place at the moment, and I think it will have make real problems for our system.
Anyone else?
There's not any direct system that you can look at which has exactly the same system for contribution collection as is proposed here. So every system has its own different features, but just by way of example, in Finland there is no contribution system unless the case is viewed as being so minor that a sentence of imprisonment of less than 4 months is expected. In other words, anything where there's any substantial period of custody, there's no contributions. The same applies in Ontario and England and Wales, where if there's a question of custody, there'll be no contribution, whereas here you can find yourself trying to collect a contribution at the moment, modest, but going to be much more substantial from somebody who's now in Berlin prison or Lomos prison. And it's simply unrealistic to think for 1 minute that if you write to somebody who has just been sentenced to 12 months imprisonment and say, can you empty your post office account to pay a contribution of £400 towards what he will view as you getting him the jail, he's not going to do it.
John, do you want to come in, please?
I think,
sorry, Jenny. Yes.
James Wolfe.
Do you want to come in, Mr. Wolfe?
Yes, I think just to say that it is important to focus on the real practical impact of an increase of self-representation, the impact of solicitors having to withdraw from acting in the course of a case, on the smooth operation of the system. And I do come back to the fundamental point that it's just simply not fair for someone who's not convicted to have to bear the cost. And I entirely see the logic that would involve introducing some system for recovery of persons who currently have to bear the cost of their defence. That would be an improvement to our system if such an arrangement were introduced.
Somebody else? Yes, Ms. Molony.
I'd just like to continue the point we were discussing earlier. And Convener, you mentioned that disabled people would have to present heating bills and shoe bills. I think this is relevant to your question from the point of view of the impact on the system, because it's not even as straightforward as just presenting the bill, because the bill would then have to be, the heating bill, for example, would have to be compared with the standard average heating bill of a home of that size with that number of occupants in that area. So the criminal justice system would somehow have to have sort of benchmark measurements in order for solicitors to actually try and assess what the disability, what the additional cost of living with disability was in that in that matter. And I think the complications involved in that really shouldn't be underestimated.
Right. Fine. I'll have John now, please.
Churn's been mentioned a couple of times, panel, and I'd like to ask Mr Harrower to perhaps if he could expand on one of the examples he gave earlier. And we've heard about the implications for perhaps the accused, the solicitor, but on the process, you mentioned a particular example I wonder if you could expand on, Mr Harrower, about domestic abuse, where there was a timeline there. I think you said 8 weeks, if I noted you correctly. Can you explain the implications, the wider implications of that for the criminal justice process, not least the alleged victim of that, please?
The domestic abuse court is a pilot project in Edinburgh, and because these are anxious cases, what the pilot court tries to do is fix a trial diet in cases which are disputed, when a not guilty plea goes in, within 8 weeks of the initial appearance. It'll be less if the person's held in custody. Now, a solicitor then has to do a number of things once a not guilty plea goes in. He has to obviously take his client's full instructions to see what avenues of defence are to be explored. He has to obtain a full copy of the disclosure case from the Crown, that's full statements. He has to get any technical evidence from the Crown and try to be ready for that trial diet in 8 weeks' time. In most other cases, it's around about 26 weeks, I think, from the initial plea of not guilty to the trial diet, which is more than the government wanted. But as I said already, I think the courts at service have told Audit Scotland that that's because cases are more and more complex. So in that time frame, whether it be 8 weeks or 26 weeks or 40 days, we're trying to get the case ready. And one of the aspects of that is applying for legal aid. It will either be a ABOR application or a legal aid application. Now, we have to, at the moment, obtain financial documentation from the client to get that legal aid application backed up and vouched and verified. There is a pre-trial hearing in cases where not guilty pleas have been tendered called an intermediate diet. They were introduced a number of years ago to try and improve efficiencies of the system. They did do that. And one of the things the sheriffs want to know at intermediate diets is whether we're ready for trial. Now, if a major aspect of being ready for trial is whether we have managed to collect the contribution or not, or whether there's a system in place for getting that contribution, which we can be sure will produce the full contribution by the end of the case, which may be even after the end of the case, unless we can be sure of that, then we will have to say to the court, we're not ready for trial. Already, I'm aware of cases in the sheriff courts when these proposals haven't even come in yet, but what the club have done recently is to increase the number of checks that they want us to carry out. As I've already said, we have to say that we've seen all this financial documentation. Start of August, they introduced new guidelines about that. Already, cases have now been continued without plea at the first calling. That means the guilty plea isn't being put in, or not guilty plea isn't being put in. The case has been continued without plea, so that the solicitor can be sure he's going to get sight of that documentation before the guilty plea goes in, so that he can be sure that the ABOR application will be granted, so that he can be sure that he will be paid. And I'm aware of that happening. And it's not just getting paid. Sometimes a legal aid certificate will cover other work we have to do, which is an outlay, such as an expert report. We have to sometimes get a doctor's report about clients or psychiatric reports about clients. These are outlays. These are not things that we profit from, but we have to pay them in advance because the NHS won't give us reports very often if they don't know they're going to get paid. So if the legal aid certificate at the end of the day isn't granted, or the ABOR certificate isn't granted, then we won't get that outlay back. So there are many reasons why we need to make sure legal aid's in place before a guilty plea goes in. And if we've also got to get a contribution in place, then it's going to be yet another reason why things will not be ready in time, whether it's a guilty plea at the start or a not guilty plea at the start. So that's when the accused is represented by a lawyer, there will be more scope for not being ready in time. And we're seeing it already, as I say. What Mr Wolffe quite rightly said was that there will be an increase in party accused. We think that's inevitable. We think if you're increasing the rates of contributions for people, where people will either be unable to afford to pay the contribution, or they will come to the view before they've even been to a lawyer, there's no point in going, I won't be able to afford it, you're going to get an increase in party accused in courts. Now, at the moment, you've got hardly any people representing themselves in the criminal courts. You get a few people in the GP court, used to be the district court, representing themselves for relatively minor cases, such as being found without a seatbelt on, or a speeding case is a common one, or maybe minor assault or shoplifting. And very often you see these people pleading guilty at a late stage in the case because they don't fancy actually cross-examining police officers or whatever, because they don't know how to do it. If these proposals come in, what we think is going to happen is that you'll get to the intermediate diet. We've written to the client to say, be there for the intermediate diet, and by the way, remember your £200 contribution, please. There's a trial diet in, say, 4 weeks' time. We have to tell the sheriff we're not ready for this. And the sheriff says, well, this is not the first time it's been adjourned. Something will happen, I'm not sure what, but there'll be either suspension of the legal certificate, or we'll have to withdraw from acting, and then you'll have an accused person standing in the dock on his own representing himself. Now, the problems that will cause in the sheriff court cases will be more marked in the GP court cases, because the sheriff court cases are more complex and more difficult. The Crown will be unwilling to disclose evidence to party accused people in the form that we get it. They won't want to give them full statements with potentially people's personal details on them. They won't want to give them CCTV footage on disc. They won't want to give them expert drugs reports or forensic science reports, which they'll struggle to understand anyway. And significantly also, party accused cannot enter into what's called a joint minute of agreement with the Crown. Now, at the moment, a lot of evidence is agreed in summary cases and solemn cases because the defence and the prosecution agree that that's not contentious evidence. A document is drawn up by either side, very often the defence, and it's a complicated thing to draft, and then it's signed by both parties, and that prevents expert witnesses coming to court or formal evidence. People who've had their cars broken into and never saw anything. We can agree all that. Now, party accused can't enter into joint minutes of agreement, so you'll have people coming to court needlessly for cases because the accused person can't do a lot of the things that we can do. And also, the accused person won't have access to a lot of the information that we get.
Sticking with the domestic courts, that a manipulative accused, and I appreciate they are an accused at that point, would find non-payment as a way of further aggravating the situation.
I think so. I think if an accused person sees the writing on the wall and sees that at the end of the day he may well be getting a jail sentence, and it may be in his interests to delay this case as much as he can because nobody wants the evil day to come, then this is yet another way of delaying the case if he fails to make a contribution to this solicitor and then the next one and then the next one, because we don't know whether an accused person will be barred from going to another solicitor or not.
Convener, there may also be an impact on somebody who's awaiting a trial in the normal run of things and is behind a party accused who hasn't paid his contribution. That trial inevitably will take far longer and delay the running of everyone's trials for that day, and people will find their trial adjourned because a sheriff is having to make sure that an unrepresented accused receives his convention rights, has the whole procedure explained to him before the trial starts. Objections to evidence would take far longer. The sheriff would have to make sure that he's given the person who has no knowledge of the legal point that's arisen time to go and research that or have it explained to them, where a solicitor may be able to deal with the matter very quickly. So that's another way in which the justice system would be slowed down if this system comes in with people who really can't afford to pay a contribution being asked to do so.
Is there not also the prospect of, through a trial at summary or solemn, where it has to stop because legal aid has been, we don't know, but not at solemn, sorry, but at summary legal aid has been withdrawn, that you have to make sure you've got the same sheriff back who's heard part of the evidence? Mm-hmm. Is that not another unintended consequence, that that sheriff has to come in to hear the continued trial?
When we get to the trial diet, whether the person's going to be represented or not, I think sheriffs will try very hard to avoid having party accused standing before them conducting a trial, because they know themselves just what a difficult situation it is.
To accuse, I'm talking about, you know, a trial that's continued over a period of days. I mean, maybe this is an extreme case, but the legal aid certificates, let's presume it's withdrawn, and therefore you have to adjourn the trial to await the solicitor finding out what the position is. But you have to make sure it's the same sheriff that's back the next time. That sheriff surely is committed to other diary commitments for further trials down the road. I'm just looking at the ripples that can come out from something
like that, I'm sure. The fact of the matter is that very few cases that go to trial in Scotland actually last more than a day. And some of the figures that SLAB, I think, have put forward for case costs really reflect scenarios which are very rare. I mean, I don't think I've ever done a summary trial which has gone to a third day. I may soon, and that was a pretty serious case, which... but most trials cases are dealt with in the same day, and so the fees are relatively low, and they will still be fully covered by the contributions that a lot of these people are going to have to make. So it won't be contribution, it will be funding.
Convener, part of the difficulty in answering your question is there's been no piloting of this scheme at all. It's uncharted waters, and the plan is to bring it in without doing any kind of pilot. So we can anticipate a number of very real problems, but nobody will know for sure how many of those there are going to be until it's in, and then it'll be too late.
Alison, you want to?
Yes, it occurs to me, listening to the discussion, that there's perhaps a particular problem thrown up in relation to domestic abuse cases, and I'd welcome the panel's view on that. If the assessment of the ability to pay is on the household income, then surely you're adding a very particular insult to injury if the victim of domestic abuse has to pick up the tab for the defence of the person that's accused. Would that be the case, and if so, is that a particular problem?
Because the executive party has an interest in it, which is contrary to the accused, they will not be taken into account in that situation.
That's helpful.
I think most of your evidence is in agreement that £68 is an unrealistic threshold. What is a more realistic threshold that you would like to see?
The exact figure for what would be the appropriate level isn't really something that we have the ability to do research into. But, for example, the Joseph Rowntree Foundation report, Minimum Income Standards, that was published only in July of this year, stated that a single person needs to spend £192.59 a week to reach a minimum standard of living. And that's when they are anticipating what might be coming. Nobody is anticipating that next week they might be charged with a criminal offence and putting money aside to pay a contribution for legal aid. So to say that £68 a week is a reasonable level, it's so far off that mark that a substantial increase in the figures would be required, but an exact amount as a starting figure it isn't really something that the society could give, but that's an indication of how far off the mark we think they are at the moment.
Because no one has asked about the Public Defender's Solicitor's Office, I'll ask this, I think, and then I'll just ask the panel if there are any parts that we haven't touched on that we should have asked. But it seems to me that there may be a role for the Public Defender's Solicitor's Office to step in if contributions are unpaid, and they can step into the shoes of the accused solicitors. Do you see that as a possibility? That's the first part. The second part relates to section 24(3) of the bill, where it seems to suggest that where solicitors employed by SLAB, as they are in the PDSO, SLAB will take on the function of collecting contributions. Now, it seems to me that if they're going to do it for the Public Defender Solicitor's Office, why are they not doing it for all solicitors? So the first is, do you think they can step into the shoes and that takes away problems in summary cases? And the second is this simply unfair? The second one.
I can answer that. We have raised that with the board, and we are told by them that the PDSO will be expected to collect contributions as well as private practitioners. So they can't actually be the safety net in that situation.
Right, okay, that's that one dealt with. What about stepping in? Do you see, for instance, Mr. Harrower, that there'll be a role? Can't you make a comment on that?
Sure. Certain people at SLAB would love that to happen, but I don't think there's enough of them at the moment, and if you're going to expand that system, it's going to be a cost. And, of course, it doesn't take into account the fact that the accused person has a right to representation of his choosing under the European Convention. If you're going to have everybody who's left standing in the dock represented by the PDSO, what happens if they fall out with the PDSO? There'll be nobody left to go to. There'll be nobody.
fall out with them?
I'm sure they do.
Oh, they do, right. You know, you're the man at the chalk face, as it were. Can I ask, as you all are, can I ask if you've anything, don't feel obliged as time runs on, if anyone feels we haven't touched anything, I think we've given a really good airing, but there may be something we haven't asked about that we ought to have asked about. Do you feel that we've... Silence is wonderful. So can I thank you all for your contribution? It's been very useful indeed. I'll sit for 7 minutes till the next panel. Thank you. Thank you very much. And can I welcome our second panel of witnesses, Dr. Colin Lancaster, Director of Policy Development, and Kingsley Thomas, Manager of Criminal Legal Assistance, both from the Scottish Legal Aid Board, and Professor Alan Miller, Chair of the Scottish Human Rights Commission. Can I thank you all for your written submissions? I know you were listening to a previous evidence session, which is very helpful to us all. Can I invite questions from members, please? John Finney.
Thank you, Convener. Panel, I'd like your views on the policy memorandum, paragraph 92. Professor Miller, you'll be familiar with this, and if I may quote, there is nothing in the provisions of the bill which has a practical effect on the extent and quality of the preparations for the trial and the right of the accused to have effective legal assistance. Full stop. New sentence. There is nothing which puts the fairness of trial at risk. Could you comment on that, please?
Yeah, thanks very much for the opportunity to speak with all of you, and thanks for the question. That's precisely where I had my folder open, and that was the sentence I had underlined, because I think you are presented with a real challenge in deciding what to do with Part 2 of this bill in two respects. The first, in direct answers to your question, is that the government seems to be making assumptions that there will be no risk to the right to a fair trial by any of the measures in the bill. I, like you, sat listening to the evidence of the last hour, and there clearly are a number of significant risks to be considered. Whether you agree with them all or accept them all, they have to be considered. So, do you want more assurance rather than the assumptions that the government's asking you to make that there will be no risks attached to this bill in its present form? I think you should seek more assurances, either through a proper human rights impact assessment to be able to identify, as we have begun to do, what some of the risks are, or a pilot to then take some evidence, or a sunset clause to be able to re-evaluate. So I think that's the first challenge you have, assumptions and assurances. Which are you going to be looking for? And then the second is, I think it's undoubted that there are risks, and how you weight them, how much quality you think there are in these risks. Is it proportionate to the potential savings that has been assumed by the government in the area of £3 million? Because if you take the view there are real risks here, we may or may not be able to manage or mitigate them, but taking a step back and looking at priorities of government spending, the impact of this, is this really worth the candle to go further down the road?
Thank you, John. Rod.
If I may, I'd like to ask Mr. Thomas in particular for any comments on the matter I raised in the first evidence session about ABWR and non-contributions. Does the board have any information on the level of non-collection of contributions for ABWR that they could share with the committee at the current time?
Yeah, I mean, the information we have, we're finalising our kind of end-of-year information for the year 11-12, but for that particular year, ABWR cases, which I think you were picking up on, there was a total contributions assessed of £154,000. 6.2% of the ABWR cases that were granted and submitted to us had a contribution payment. So relatively small figures, but not in substantial amounts.
You don't have any information on the levels of contributions not paid?
Well, we don't know because we don't collect them. It's the solicitors who would collect those contribution payments. We heard from Mr. Harrower that maybe not many of them do, although we are aware that some firms do collect the contributions. How it works in practice is that we pay the solicitor's account net of any assessed contribution.
Could I also ask you, if, I know it's not in the bill, but if the board were to collect the contributions for summary legal aid, particular or indeed for ABWR as well for consistency, what would be the impact in terms of cost to the board? What kind of expenditure are we talking about?
We have done some initial analysis of that, and we reckon in terms of the extra resources, staff and system resources, it would be in the region of an extra £600,000 per year.
And any general comment on what I think are quite modest levels of savings which are referred to in the financial memorandum?
In terms of the £750 threshold for disposable capital?
No, the general estimated...
sorry, the saving.
The 1 million, just over £1 million for ABWAR, just over £2 million for Summary, and 830,000 for Solemn. Those seem to be quite modest figures for being put forward. Any general thoughts?
The savings figures are calculated on the basis of the figures that are elsewhere in the policy memorandum in relation to the rates of contributions, the number of people who would be likely to pay them, and how those contributions would be calculated. So one is a direct result of the other. So if the thresholds were set differently, if the rates of contributions, the percentage of disposable income which would be taken was set higher or lower, then obviously the rate of savings that would flow from them would also change. So what's set out in the policy memorandum is a scheme of contributions that would deliver that level of savings. If you wanted a different level of savings, then a different scheme of contributions could be constructed to deliver that.
Against the current budget of 20 million for ABWAR and 35 for Summary, it's actually quite a modest saving.
Well, I think it's a saving that balances the need to reduce overall expenditure on legal aid, but recognising that asking clients to pay substantially more would actually be problematic. So I think there's a balance there between achieving savings which are meaningful, and we must place these proposals in the context of the wider savings packages which have been put in place for legal aid over the last couple of years. We, although we have a demand-led budget for legal aid, there's no cap on the legal aid fund. Obviously, government has to make provision for legal aid, and the provision which government has felt able to make for legal aid has gone down, notwithstanding that they would remain committed to paying more if demand required it. So they've put in place a number of measures to deliver savings, and those look at civil legal aid, criminal legal aid, at eligibility, at scope and at fees. So the approach that ministers have set out is that they want to try and achieve savings while preserving access to justice. If we look at other jurisdictions, we see that there are different ways of achieving savings. In England and Wales, for example, large parts of social welfare law have been taken completely out of scope of civil legal aid. That's not what ministers have said they want to do in Scotland. They want to preserve scope, but to find savings, they've got to look at each of the areas. Here, what they've said is that, as a general principle, those who can afford to make a contribution towards the cost of the help that they receive should do so. So the question is, how much should they pay, and how do you determine who can afford it? And that was what much of the discussion with the previous panel was about. But the levels of income and the contribution rates that have been set, as I say, produce that saving, which, alongside other savings measures which have been put in place, should result in the legal aid fund coming down to a level which the government views as being sustainable in the longer term.
Finally, could I just ask a question on the mechanics of completing the application online? We had a lot of talk in the first evidence session about producing various bills to show income levels. In practice, how would you see the mechanism of completion of the application in terms of the financial information being required?
It wouldn't actually change because the legal aid applications which are being made to us in Summary and Solemn legal aid already have to give us the kind of financial verification information we're looking for. And we shouldn't forget that a substantial majority of clients who are applying for criminal legal aid are in receipt of benefits. And we actually have an automatic link with the DWP to verify these benefits. So we're not looking for much information to verify these ourselves. So the way it works at the moment, the online system, the legal aid application is sent to us, and bank statements or any other information to confirm income or outgoings can be scanned into us and are sent to us, and it works pretty well at the moment. So that's not going to change with the introduction of contributions. That will continue.
Can I just ask on this 3.9 million of savings, is that calculated on 100% recovery?
The figure that's in the FM was the maximum saving that could be achievable with this contributions regime if there was 100% collection. Now, as Mr. Harrower mentioned earlier, we'd looked at various sensitivities in relation to our own collection of solemn contributions, and so there's a range there of what we might be able to collect. As far as collection by solicitors is concerned, because of the arrangements that are set out in the bill in relation to collection, the savings are achievable. The savings which are achievable are not dependent on the extent to which the contributions are actually collected by the solicitor, because the system that Kingsley described for ABWOR at present is what would be adopted for summary criminal as well as ABWOR in the future, whereby the solicitor's account would be submitted to the board and it would be paid net of the contribution. In other words, there would be an assumption that the contribution was collected. And
carry the loss.
If they didn't collect the contribution,
yes,
they would carry the loss. If they did collect the contribution, obviously they would get their payment sometimes earlier than
that's how you're able
board.
to do the 100%, because you're saying, well, you know, tough, they take the loss if they don't collect.
It doesn't assume 100% collection. It's just that once the contribution is assessed, the saving is achievable. The
second thing I wanted to ask about this figure of 3.9 million, is that net of any administrative costs? Even though you've got online, you may have challenges where legal aid is refused by the board and the solicitor has to come back with further information or whatever to you. Are there no administrative costs in running this?
A small amount
to chip
in the
away
financial memorandum. I think was it 100?
Yeah, I mean, yes, 103,000, which was to cover a few extra staff in my department, criminal applications, but also in our department that deals with recovery of sums for the solemn cases. But the kind of thing you're talking about there, convener, is what we're used to. We do that day in, day out at the moment with cases which are initially refused and then.
And I've just asked if this figure was a net figure, taking into account, you've explained 100%, understand that losses will be carried by the solicitors because, you know, you're going to take it off their bill. And you've also told me now the administrative costs are peanuts, 100,000, something like that. So it's really, I shouldn't bother. It's 3.9 million. That's the figure.
I suppose if you take the two parts that are in the FM and net one against the other, it would be 3.8 million. So
3.8 million. I've taken a little bit
100,000.
off it. Right, 3.8 million. Jenny.
Excluding the transfer of liability that SLAB might have to pick up as a result, how much more onerous would it be for SLAB to collect criminal summary contributions? Because you're already collecting civil contributions and you're going to be collecting solemn contributions. So apart from the transfer of liability, which the convener has just alluded to, how much more onerous would it be on SLAB to collect the summary contributions as well?
Some of the figures are quoted in the financial memorandum of the number of cases that we're expecting will have a contribution to recover. It's about just under 2,000 kind of solemn procedure cases we reckon will have a contribution to recover, and that was the kind of extra resource the small extra resource that we felt we needed to do that. If we were to recover also the summary and the ABWOR, then that would be an increase of just over 17,000 cases. So it goes from us collecting 2,000 solemn cases to a total of 18,500 combined criminal cases. So a significant increase for the board to kind of deal with.
I mean, in terms of sort of day-to-day operation, what does that equate to? Is that 3 or 5 members of staff or 20 or... You know, in comparison with solicitors making all these collections and the Scottish Legal Aid Board, who already have a system in place and presumably the IT to collect these contributions and staff that are trained up in mechanisms of collecting contributions. I mean, how much more onerous practically does that extra 17,000 case contributions make for the organisation?
He's looking for the extra staff numbers. I think one thing that's worth pointing out is that in relation to civil legal aid, we have maybe a couple of thousand contributions cases which we open each year. The average value of a civil legal aid contribution is around about £2,300. So we're setting up an instalment arrangement with the applicant to pay over an extended period of time a fair sum of money. So 2,000 cases at about £2,500 each. We'd be looking at a far, far larger number of cases, the vast majority of which would be very much smaller. I mean, the evidence earlier seemed to imply that we'd have all these people who'd be meeting the full costs of their case, and that the maximum contribution of £1,000 would be very extensive indeed. But that would be a very, very small minority of all applicants and a very small minority of all contributions cases, the contributions are far more typically going to be under £50 or between 50 and 100 or 100 and 300 pounds. We're not talking about the size of contributions that we are typically dealing with and the instalment periods that we typically allow for civil legal aid, because for civil legal aid we're looking at somebody paying at the basic level a third of their annual disposable income by way of contribution. For a lot of these criminal cases, we're looking at somebody who's going to be paying maybe 10% over a 13-week period.
And that it's going to be lots of cases and a lot of the payments will be quite small, as you've just said, but how much of an actual impact would it have on the Scottish Legal Aid Board to collect the contributions yourself? I'm talking about cost, staff numbers, hours. Has there been any kind of assessment made of that? Yeah.
I mean, as I said, the additional cost was on of us collecting summary and ABOR contributions with the region of just under 600,000, 594,904, and that was largely from the additional staff that was required. If my arithmetic's right here, an extra 16 collection staff, a team leader and a deputy team leader. So,
which would, I think, be more than a quadrupling of our current Treasury complement in terms of their collection.
That'd be a quadrupling of what,
quadrupling of our current arrangement. So the team that we have collecting those civil contributions is relatively small. We would need a far, far larger team to be able to collect the volume that we'd be looking at here. So I think what I was trying to say earlier is that the cost of us setting up all of these arrangements centrally is disproportionate to the value of a lot of the contributions that are going to be assessed in these cases. The same is not true of civil legal aid, where the contributions tend to be higher.
If I can pick up a point the convener put to the earlier panel about, and perhaps you're not concerned with this, but I'd like to know your opinion about the fact that somebody could be represented by a solicitor and not pay their contribution, and then they could go to another solicitor, and you know that solicitor wouldn't know that they were a non-payer or a non-contributor. If it was centrally managed by SLAB, surely that would overcome that problem, which I think is going to be a problem.
I don't know how significant a problem that is likely to be. We have no way of knowing that. What we would say is that, again, the earlier session seemed to imply that every client was a new client and the solicitor had no knowledge of them, whereas what we know to be the case is that many clients are repeat clients and solicitors are very well aware of their clients' circumstances and their behaviours and how to interact with them. And it's on that basis of that extended relationship, that ongoing relationship between solicitor and client, that we think the solicitor is in a good position to manage that relationship and the payment of the contribution.
Lancaster, would you agree with me that perhaps the repeat client pattern might actually not happen as a result of this, because the client is not likely to go back to the solicitor to whom they are owed money, and so perhaps that breaks down as a result of these proposals?
I think solicitors will make a commercial judgment as to how they decide to respond to a client who doesn't pay, just as they do at present and just as they will with private clients. So the solicitor will look at the client, look at their history with the client and work out whether it's worth severing ties with this client for what might be a small contribution for a client who actually has delivered repeat business to the firm, is likely to deliver repeat business in future, and may well deliver solemn business to the firm, where, of course, a contribution would be payable to the board.
It's a very special way of looking at the justice system, you know. I'm investing in you because you're going to commit murder or rape at some point, you know.
No, I'm not saying that. What I'm saying is that a lot of these solicitors have a long-standing, ongoing relationship with their clients, and they will form judgments on what they're willing to do for that client in terms of foregoing some of a contribution on the basis of that relationship.
I'll move on to Graham, followed by Alison, please.
I think many of the substantial questions that I would ask have just been asked, but just to finish this final part of it, in the earlier session, I invited the panel to give a view about someone who's failed to deliver their contribution. In that case, it's concluded they still have failed to pay their piece. and they come back into the system on a fresh charge. If SLAB were to take responsibility for that scenario, it wasn't for solicitors to take the hit, if we can put it in the vernacular, but it was within SLAB's environment. Would you imagine that the policy would be that because of a failure to pay in an earlier case, you were not able to access the system for assistance thereafter until that bill was paid? Or would each case be seen as separate?
I think we'd have to look very carefully at that. I mean, I can see where you're going with that, and there would potentially be risks to the operation of the system if we were to take a blanket approach that said if you're an outstanding debt, you couldn't come in. I don't think that would be a reasonable position for us to adopt. People's circumstances do change. There can be legitimate reasons that they were unable to make a payment at a particular point in time. And what we have to look at is whether or not this person is committing to us to make a payment in relation to the case that's presenting in front of us.
And
we would still continue to pursue the contribution.
Indeed, and I'm grateful for that answer. Going back to the earlier point you made about the solicitor being responsible for obtaining the payment, would you accept that in some areas what we're actually viewing might be anticipated as being a new discount to the fees, and that it's unlikely that they will be able to collect 100% of these fees from the client group involved, and therefore there's a presupposition on the part of the policy that a private company will merely take that hit, as you say, in the interest of the longer-term business?
I think one thing that there was no discussion about in the previous session was how solicitors currently get their fees from their private clients. And we do know that solicitors have private clients. And there are many firms that do quite a lot of criminal business, particularly in relation to Road Traffic Act work for private clients. And they obviously have measures for recovering their fees from those clients, and indeed they'll have a point at which they may decide to write off some of those fees. And we would imagine exactly the same kind of thought processes going on in relation to legal aid clients who owe them fees. They may form a judgment that they will let a bit of the contribution go. Again, there will be a commercial reality of thinking whether or not it's worth pushing it with a particular client if the risk is that that client then goes to another firm. So I think, again, as I was saying, on a client-by-client basis, they'll form a judgment about what it is that they're willing to take.
You would accept, you mentioned the word reality there, you would accept that for many clients £100 is a king's ransom?
I think, again, the previous discussion didn't, I think, adequately distinguish between income and disposable income. What is proposed in the bill for ABWR is a move from a system where you take the income, you take off dependence allowances, and then that's it. You arrive at a figure, you look that up on the key card and say whether the client is eligible or not and what size of contribution they've got. For summary criminal legal aid, at present, we have a more bespoke assessment which looks at income and outgoings. For civil legal aid, we have a very bespoke assessment which looks at income and outgoings to arrive at a disposable income figure. And the disposable income figure can often be very much lower than the income figure. And the move, the £68, as we say in our evidence, our modelling suggests that the £68 is, on average, equivalent to the current lower income limit in ABWR of £105. So that gap is made up of outgoings, which are currently irrelevant for ABWR purposes. So if you've got a client who has rent, council tax, childcare costs, transport costs, those will all be deducted from their earnings. And we wanted to try and find some examples for the committee of the difference between that kind of gross income approach and the net disposable income approach. We can certainly send a number on to the committee after this session, if that would be helpful. But just to illustrate, we've got an example of a cleaner who's been charged with drink driving. They earn £321 per week, so that's well above the Joseph Rowntree Foundation figures that Mr Moyer quoted. He had no dependents, but he did have outgoings for rent, council tax, a car loan and car insurance. That reduced his disposable income quite substantially. It took it down to £90. So he was eligible for summary criminal legal aid. However, for ABWOR purposes, his income would have been assessed as £321. So he'd have been well above the current upper limit, which is £245. So there's a client who was eligible for summary criminal, wouldn't have been eligible for ABWOR at all. Under the new system, he would have a contribution of £56, which we worked out as being 3% of his disposable income over the 20-week assessment period. And for ABWOR, he'd have a contribution of £44. This is the ABWOR for which he would have been ineligible by about £100. And that's the difference between disposable income and gross income. It's a very big difference, and it would make a substantial difference to a number of people who currently have outgoings. They have inescapable commitments, which mean that they don't have the flexibility to meet the costs of a lawyer. That's taken account of in this assessment. The people for whom this change would be less of a benefit would be those who have a reasonable income but have no outgoings. And again, as we say in our evidence, we think that they might reasonably be regarded as having more flexibility to meet unanticipated costs than the person whose entire wage packet is spoken for before they've looked outside.
I would probably suggest that to the person to whom £100 was a king's ransom would probably qualify anyway and would not have that contribution to pay. I mean, one of the examples I think was given of the person on minimum wage with no outgoings. Now, I think the reality is that we would find it very difficult to find an example of a person who had absolutely no outgoings. Even a youngster was sort of working on minimum wage, living at home, was more than likely to be paying some kind of rent or board payments, perhaps to their parents, would have some kind of loans or would have some kind of outgoings that we would take into account in this calculation. A lot was said of the £68 threshold, and as Colin mentioned, it is worth to stress that it's a disposable income threshold, not an actual income threshold. But it also equates to the same free threshold for civil legal aid. And I suppose the point has been made was, should there be a higher free threshold for criminal legal aid than there is for civil legal aid?
I understand the points you're making there, and in a project that looks fine and the science of it looks lovely, but many of these families don't exist in a bubble. They support others within the network, and it'd be difficult to put in your form to give my daughter £15 because she had nothing. I had to give a friend, because that's the kind of social life many of this client group will have. I can't see how your system will be able to capture that information in a way that you would be able to go to your box and say, tick, I can acknowledge that, or I don't think that £15 was well spent.
That's what we do.
Yeah, I mean,
so even if a client group's daughter-in-law is short of money for that month and they hand them cash, you would take that into your computations?
I mean, we can look at things like that. I mean, I think that was why we were really keen on promoting the undue hardship test here, which gives us flexibility to look at assessments in a sensible way according to the individual circumstances. What we didn't want was a hard and fast, rigid test like we already have in the Advice Assistance of ABWOR, saying, well, what's your income? Take off an allowance for dependents, and that's it. And too bad if you're having to pay extra for your, for this month. Nothing can happen on it. We do this day in, day out. We take judgments based on individual circumstances. And although the applications for legal aid are made online, and yes, the information comes into us electronically, we can step back from it. They're looked at by humans, and we can look at the situation and take a sensible approach to these financial matters.
So the hardship test is the discretionary part of it. Can I ask then, just because I was looking at this just where you got on, currently in solemn procedure, it's the court which applies.
No, not anymore.
That's what I'm asking.
That transferred over to the board in November 2010.
So November 2010, it went to you as well. So everything's in within your ambit now, the undue hardship test.
Yep.
So what I understand by this is that even if somebody is deemed to, on the paper, then the ticks and the boxes that Graham's referred to be required to make payment, you could look beyond that and say, but that must imply more work for the solicitor at the end of the day to submit extra stuff to you, for saying, well, in these circumstances, undue hardship, for which they are not being paid.
Well, I mean, that may be the case. I mean, I suppose, yes, what we're saying is that under the ABWOR test, which at the moment is a rigid test that the solicitors applied, the nature of how the undue hardship test will be fully explained and published to them. But it's still, the flexibility will still remain that if you, because you can't always fit people's individual circumstances to a kind of policy document as to how you assess their contributions or how you assess eligibility. So what we've said in the ABWOR situations where the solicitors will be doing this test, if they feel that there's something else which ought to be taken into account, which isn't covered by any of the guidance which we've issued, yes, they can ask us for our opinion, for our view on that. Now, how often that will happen, well, we don't know, but I can assure you that my department is well able to kind of deal with these things on an urgent basis.
Now, that's the key, urgent, because if you're in civil proceedings, the pursuers get time. Now, they're thinking about legal aid before they raise the proceedings. And the defenders get time in civil proceedings to make an application for legal aid. But from what we were hearing from the solicitor there is, somebody might just walk into your office with the complaint or the summons and whatnot. So, you know, it's urgent stuff. So they may not have time for these niceties that occur within civil legal aid applications. How is that going to operate? You know, let's take an undue hardship case where on paper they're not entitled, but you get the background, the girl that's getting the money and all that stuff, and they're in court the next day. How's that going to work in practical terms so that they're represented by a solicitor who's covered by legal aid?
It happens at the moment that we're phoned up by the solicitor if they have in that situation, you know, for advice on the spot there and then. So we'd be able to deal with that. I don't really see that being
appearance, not advice. An appearance the next day. Will they be covered?
Yeah, we can give them advice.
Yeah,
they can tell us there and then what the circumstances are, and we can give a view. I mean, in terms of the turnaround time that we've got for returning a grant once the application's made, we do well, it's a ridiculous proportion very quickly.
Yeah.
For Kingsley knows the numbers better than I do.
Yeah, for the cases where we do an assessment on, the summary and the solemn cases, it takes us on average 1.1 or 1.2 days to assess these cases, and we prioritise cases which come to us where there's within 4 weeks of the next court appearances are dealt with on the same day we receive them, and we would continue to do that.
So what you're saying to me is somebody comes in with a complex financial background, the court appearance is, let's say, the next morning, the solicitor would be able to know one way or the other whether they had cover for that appearance.
Yes, I mean, they would seek advice from us, yes.
Right,
that's all I wanted to... Yeah.
Sorry, the other point relates to the verification information. Doesn't all need to be provided at that point in time. And I think that's another one of the concerns that's been raised maybe in relation to custody cases here, where somebody won't have that information to hand. And I think what we would envisage is that where the solicitor is doing the assessment, they're effectively assessing the client on the basis of the information they have before them. But if subsequent information comes to light that suggests that the client does have outgoings that would either make them eligible when they've been assessed as not, or that would reduce a contribution that's been assessed or remove a contribution, then that could be forwarded on when it does come to light. Well, if effectively what we'd be doing is saying that there was a change in circumstances that had come to light that suggested that the information at the point the grant was given, it was a valid grant, but actually the client's financial circumstances have become clearer since the grant was made, and as a result, the contribution could be reduced on that basis.
Or increased.
Or increased.
Or they don't get cover at all.
Well, if there was a change in circumstances where somebody came into money,
no, I'm not meaning that.
Again, we have this at present where if the information that's given is incomplete and it subsequently comes to light.
No, I'm not talking about winning the lottery stand. I'm talking about somebody bona fide solicitor takes, in urgent circumstances, take the financial information from the accused. They get off to you that day. They've got to be in court the next day. They need to know they've got cover. You give them cover. They then find out it was porkies they were told, yet they filled this in good faith. Are they still covered for that appearance?
What happens at present if verification isn't produced?
Yeah, I mean, it's. I mean, at the moment, if the solicitor doesn't see verification, I mean, because the solicitors are making grants day in and day out on advice assistance and ABWOR cases, but the board is requiring the solicitor to have seen evidence of the client's financial circumstances before they can make that grant. Legal aid is a state benefit which has to be verified. But if the solicitor's not able to see that verification, if they can explain to us why they were not able to see that verification, we can take a judgment as to whether or not the grant was a valid grant and pay the solicitor. But if the solicitor just has chosen not to seek any verification, then...
Bona fide,
yeah.
good faith. So
yes,
that's parked.
Yeah, I mean, there's a lot of elements, I suppose, of the legal aid. If the solicitor does something in good faith, they will be paid for doing the work that they had done.
So that's fine. I hear that in the record now. If in good faith they do something urgently and they've got to fill in this form and they're told there's no contributions or such and such a contribution, and it all gets changed and they find out after they've done an appearance that in fact this is not the case, this man or woman should never have been given legal aid in the first place for this, they'll still get paid if it was done in good faith.
It's difficult to give a... Yeah, but I mean, we would look at the circumstance and where it was fair to do that, we would do that, yeah.
But we're not envisaging there being any change from
Sorry,
the current...
that was a maybe, yeah, I think you're right, that was a maybe.
We're not envisaging there being any change to the current situation there. At present, solicitors have to do that assessment, they have to then provide the verification, and we have questions of whether that verification actually satisfies us. So the bill doesn't make any change to that.
So it's all steady as she goes. There was that a yes. You can't smile, doesn't appear in the record.
No, that was a yes. There's no change to that process.
Alison.
This is all very illuminating. It's not transparent. It's not my idea of 21st century access to justice, I have to say. You heard the previous panel, you heard Mark Harrower say that basically this is a backdoor attempt to reduce solicitors' fees, that you know that they won't be able to collect these fees. If the government had concluded that you should collect all the contributions for both the summary cases and the other cases, would you be sitting here telling us that it's such a good idea?
But the contributions were a good idea. We think that absolutely contributions in principle are absolutely right. I think, again, the Cabinet Secretary made clear in the Sustainable Future for Legal Aid paper that, as a general principle, those who can pay should pay. Those who can afford to make a contribution towards the costs of the assistance that they're being provided with should pay towards those costs. It's something that happens currently in ABOR, it's something that currently happens in civil legal aid, and there seems no reason why we should have a system in criminal legal aid which requires us to grant legal aid to somebody whose disposable income would require them to pay a contribution were they to have a civil case of £2,500, but it requires us to grant free legal aid to them when they've got a case which is going to cost £300. It seems to me absolutely reasonable that a person in those circumstances can afford to make a contribution or indeed meet the whole cost of their case, but the current system doesn't allow that.
You said earlier that it was your daily bread and butter, collecting fees, collecting these charges. Why then is it not the most efficient way for you to actually roll this out and collect all of the charges?
I think what we said was that it was our bread and butter assessing eligibility and taking decisions on cases. It's something that collecting contributions is something that we do on the civil legal aid side as well. But I think you mentioned there collecting fees, and I think this is where this whole discussion is a little bit strange. What we're talking about here is a system whereby the state pays the fees to solicitors on behalf of people who cannot pay those fees themselves. They're the fees of the solicitors, and we're talking about a system where we would collect the fee from the client and then give it to the solicitor, rather than the client give their fee to the solicitor for the work that the solicitor is doing for that client. So it's their fee, and it would seem unnecessary for us to become involved in that process. We don't get involved in that process for private clients, and I'm not sure why one would say that we would be needed to collect the fee from a legal aided client, whereas solicitors have mechanisms to collect their fee from their private clients. They wouldn't suggest that we should be an intermediary there.
You heard from the previous panel that basically there were administrative senses in being able to do it in that way, because we don't want to see further churn in the system at these intermediate diets where people say, well, we're not ready to roll because I'm not sure I'm going to get paid. Do you not think that that confuses the whole landscape?
Again, I'm not aware of solicitors turning up in court saying that they can't proceed with a case for a private client because the private client hasn't given them their latest instalment. I'm not sure. It doesn't sound like a legitimate reason to give to the court for seeking an adjournment. It's not the same as not being ready to proceed. It's saying, I haven't been put in funds by my client, and I don't think they do that in private cases. Can I just try and put this a little bit in context? Again, we can provide this information after the session, but we were looking at a number of individual firms to see how often they would be looking to collect contributions and what the scale of those contributions would be. And so we took a number of, sort of medium-sized firms who have fair volumes of summary and solemn business. An example here of a firm in Glasgow which between December 2010 and November 2011 had 256 grants of summary criminal legal aid. We reckon that 17 of those would have a contribution, and that the total value of those contributions would be just under £5,000. That's in the context of that firm earning £138,000 from summary criminal legal aid. The firm as a whole would be looking at collecting contributions worth £8,300, and they have a total income from legal aid of £323,000. So it would be 29 clients in total. They have 396 cases a year. We're talking about a small percentage of their business and a very small percentage of the income. And at that level, we're talking about less than 3% of their total income from legal aid being obtained directly from their client. Now, we reckon that on best estimates, between 5 and 10% of many firms' criminal income comes from private clients. So we're actually talking about adding a smaller number or a lower value of cases that they're required to collect than they will currently be collecting from private clients. So when firms say that they have no mechanisms to collect fees, I don't know how they get their private fees.
I have a separate question.
Why bother?
Yeah.
Why bother?
Why bother collecting from a private client?
Why bother having a contribution system means tested? Why bother? If such a substantial number of summary cases and such a substantial number already in benefits, then we're putting in place a whole system that seems to be saving possibly, just possibly, 3.8 million. And yet we're going to have, it's a small saving for a lot of work. And what we heard earlier was there could be ramifications in some cases, maybe not the majority, of justice. Ramifications for human rights, the pursuit of justice, people pleading, people self-representing, party, it seems to me, why?
Evidence we have from England and Wales, where contributions were introduced in Crown Court cases in 2010, is that since that time there has been no change in pleading patterns and there has been no change in the number of unrepresented accused. There has been an increase in the number of privately funded accused, but there's been no change in the number of unrepresented accused.
In Wales, I understand they can recover the contributions if successful.
And so can
in being
clients.
acquitted, but we don't have that. So it's not comparing apples and apples, it's apples and pears.
The English system is different, absolutely, and the recovery of costs from the state is part and parcel of the criminal justice system in England and Wales. It's not part and parcel of the criminal justice system here.
Not on this. I wanted to
came in because I just thought you were getting away with some stuff there. I'm not to put it like that roughly as that, but to persist a bit more with you.
If I might ask Professor Miller, in your written submission, you pointed out that you would like some clarification on the government's intention around section 17 of the bill, and I wondered if you could elaborate to committee on the concerns that you have round about the issues of seeking legal advice while in detention.
Yeah, I think in answer to that, but also just more broadly, that I think that the issue of who recovers contributions is an issue of concern, clearly. Is it solicitors? Is it SLAB? The level of eligibility, I think, is a real concern. And I'm not wanting to dwell too long on those individuals who might bring solemn business to law firms. I'm concerned more with individuals, all of whom we know in the criminal justice system come into contact with it because of various vulnerabilities, mental health, physical disabilities, and we've heard from Capability Scotland where they come from in society and their socio-economic status. And therefore, if we take a step back from the mechanics of it, legitimate as that is, and look to access to justice, fairness and proportionality, I'm not convinced at all that there has been a sufficient impact assessment done as to what the impact is going to be on individuals who are in very vulnerable situations, come into contact with the criminal justice system and are unable to pay for proper legal representation, will either have to represent themselves and the difficulties that that causes for them and the criminal justice system, or, as we heard this morning from the Law Society and others, it's easier just to plead guilty, and it's actually cheaper just to plead guilty than go through with it all. And there you're going to have invisible human rights breaches. They may not be in the newspapers. They may not go to the European Court of Human Rights. We have just finished a mapping of the last 3 years in Scotland about the extent to which human rights are realised, particularly by the most vulnerable. And what we see is that the laws can appear quite good, the policies can appear quite good, but then real life of many people gets in the way, and they actually don't get the outcomes that all of us sitting around here assume they do. And that's the real invisible human rights breaches that we have, whether it's older people or disabled people or those that are charged with criminal offences and don't have the access to effective representation. And so that's what I was saying at the beginning, that I think you really need much more in terms of assurances that that's not going to happen, and that a lot of the assumptions that are being made by the government and by my friends and colleagues here are a bit superficial, and life gets in the way of some of them.
John, followed by Rod, David after that.
You know, again, it was a question for Professor Miller about the human rights aspect. You talk about the lack of clarity surrounding appeals where the appellant dies. The appellant would have had some entitlement to have the expenses met. And I wonder, can you expand a bit further on that, please, for the record?
I think, obviously, we can only discuss what we have in front of us, and I think there's enough unknown risks about that, and the policy human rights statement, I think, is grossly inadequate, saying there are no risks attached. But then there's a lot of unknowns, and you know, I'm not going to get into the sort of Donald Rumsfeld thing, but we know some of the unknowns, and some of the unknowns are, we don't know the levels of contribution. We don't know about some of these areas like deceased contributions in appeals. And an awful lot is left either to subsequent regulation or the discretion of the Scottish Legal Aid Board, the legal profession, or some of it seems to have maybe a sort of scepticism about reliance on that kind of discretion or regulations to be made in the future. And I think from your point of view, you really need a lot more information up front about what the impact will be of what you see in front of you, but also what you don't see in front of you, and what the impact of that might well be. And really, I think a proper impact assessment is something that would benefit all of you in trying to weigh up what's being said in defence of the bill and what appears to me to be legitimate concerns about how it will actually impact in real life on real people.
John? Sorry, John, we've had Rod, sorry.
I think you've largely answered the question I was going to ask, but it's my understanding the equality impact assessment's not yet been produced. Is there anything else, obviously issues of disability possibly feature quite strongly, is there anything else that other flesh you would want to put on, or matters that you think should be in this impact assessment?
Well, I think you've been very fortunate that the first session you had today really was trying to do the work of what an impact assessment should have done. We don't have a sort of public association of accused that can come and say, this is the experience of the accused, listen to us. You know, the closest you have to that is Capability Scotland, who represent a section of the community who do come into contact with criminal justice. You have lawyers who daily have face-to-face understandings of what life is like for many of those who come into contact. That's evidence that I think, you know, really does pose very big question mark about the human rights policy statement attached to this bill, that there is no risk to the right to a fair trial. And without being sort of excessively legalistic, I think we all would agree, you know, access to justice, fairness, proportionality, you know, we all sign up to these values and principles. Article 6, the right to a fair trial under the European Convention, that's the actual hard-wired guarantee. And that's largely what is missing from the policy assessment and from the debate about collection of fees and eligibility levels. Is there a real risk that someone will not get a fair trial as a result of the measures proposed by this bill? You might think, well, maybe that's inevitable. So the next question would be, well, is that a risk worth paying? Are the savings so good that we're prepared to run that risk and hope that no one does get an unfair trial? And then you have to look, well, are the savings proportionate to the risk we seem to be running, you know, the thin ice that we seem to be skating on because of the problems that the Law Society has identified? Are the savings, you know, sufficient to outweigh those concerns, legitimate as they might be? And that's a matter for you, but I think it must be open to question as well.
David.
Thank you, Convener. Could I go back to a point which I hope I heard correctly? I think you made, Dr. Johnson, when you were talking about changes that had been made in terms of contribution rules in England and Wales. And I think, if I noted this correctly, you said that it had not made any change in pleading behaviour. Was that correct? Did I hear that correct?
Yeah, the same percentage. Over the last 5 years, the percentage of people pleading guilty has remained pretty much flat.
But what I found slightly difficult was then to square that evidence with outcomes with the statement in paragraph 11 of the slab evidence, which says that alignment of the rules of ABWA and criminal legal aid, etc., is going to actually effect change as a result of changes in pleading behaviour.
It will surprise you to hear that I don't think those two positions are inconsistent. What we were saying in our evidence was to do with the timing of a plea rather than entering a plea of guilty where one would not otherwise do so. The issue at present, and as the example I gave you earlier suggests, is that there are some people who are not eligible for ABWA at present. So if they want to have a lawyer represent them when they appear in court, and including for any subsequent plea mitigation or deferred sentence, their only option would be to apply for summary criminal legal aid. In other words, to enter a plea of not guilty and then apply for summary criminal legal aid so that they can get funding under the disposable income and due hardship test that we have in summary criminal legal aid. Under this proposed change, if a plea of guilty is the appropriate plea to make at the outset, they'll be able to do that with the benefit of a lawyer representing them because they're more likely to qualify for ABWA than they are at present. This actually increases eligibility for ABWA.
I can see that, but in terms of behavioural change, and maybe they would say that, wouldn't they, as someone once said, your evidence seems to directly contradict the evidence that we had from Mr. Harrower when I was putting questions about behavioural change to him, and he seemed to think completely the opposite, shall we say, in relation to your own submission and the Scottish Government's consultation document. So there must be some way of reconciling this, is there not?
We've been looking at slightly different parts of the evidence and the provisions. What we're talking about is people who are currently pleading not guilty because they don't qualify for ABWA so that they can get the benefit of summary criminal. In future, there'll be no reason for them to enter that plea of not guilty to apply for summary criminal. They'll be able to enter the plea that they want to make. And they'll have taken advice from their solicitor on the consequences of doing so. And if the advice is that the best thing to do, and the client's instruction is that a plea of guilty should be tendered at the pleading diet, then they'll be able to do that, and a grant of ABWA will be made to cover it. And certainly when we look back at summary justice reform and the changes that were made there to payment regimes, that's where we saw a big increase in the number of people who were pleading guilty at pleading diet. We didn't see an increase in the number of people pleading guilty overall. So there was no increase in, there's no suggestion of there being inappropriate pleas of guilty. It's just that people who would in the fullness of time have pled guilty at intermediate diet or possibly at trial diet were pleading guilty more often at pleading diet, which is the most appropriate point at which that plea should be tendered. So that's what we're saying, that the financial arrangements currently pose a barrier to some people for whom that is the appropriate plea, and we'd be removing that barrier.
Thank you.
Can I wasn't a criminal practitioner, but surely people might plead guilty later because the complaint has been amended and reduced. So you can't actually say it's the same thing they're pleading guilty to.
Nobody's suggesting that the only time at which one can or should plead guilty is at pleading diet, because absolutely things might change. There are discussions between the Crown and the defence, and when evidence becomes available, then they have those discussions and charges are dropped or amended.
What about answering the point that was raised that some very smart accused, and quite a lot of smart accused, let's take a domestic abuse case, would use the fact that they delay their contributions and refuse to pay them to delay being imprisoned, to delay the process, the criminal prosecution process. Do you see that that could be done? I mean, that was something, again, that was raised by the solicitor. They might use it for that purpose.
That all hinges, again, on whether or not the solicitor not having been put in funds would be a valid reason for a continuation on a case. I
understand that. I mean, they're not, the funds are not going to appear, and they have to ask the court possibly for... You see a knock-on effect that Professor Miller has in a broad way referred to, but the impact on justice. I mean, I think we'd all agree it's a good idea that people who can afford to pay should pay when they're in court. The problem is it's not as simple as that. There's all these other issues that are now emerging.
And the individual behaviour is a key element of that. I think somebody at the last panel talked about a safety net, and that is something that I think we need to consider for that sort of scenario, because while the accused shouldn't be able to dictate the terms of the criminal justice system by refusing to pay, we would recognise that we think that it's important that proceedings can go ahead as scheduled. And I know Mr Harrower said that there are some at the board who would love to see an expansion of PDSO. The fact is that we have PDSO available. They could act as a safety net. In 1999-2000, when fixed payments were introduced, and the Law Society, the Edinburgh Bar Association and the Glasgow Bar Association said that people would be appearing unrepresented up and down the country. The regulations were put in place to provide for a safety net whereby, in circumstances where an accused could not find a solicitor to act for them, the PDSO would act. That was never called upon. The safety net was in place, but it was never called upon. Now, we could put a safety net in place for this scenario as well, where we would say that if there was an accused and there was a risk to the proceedings, that we would have a solicitor appointed to act for them for the purpose of those proceedings. And to be honest, looking at having the PDSO doing it is simply a way of minimising any additional cost to the public purse. So if the PDSO were to do that, there'd be no additional cost to the public purse.
Would that have to be put in the primary legislation?
No, I don't think so. I mean, we'd have to look at whether or not there would be regulations required for a transfer in those circumstances, but I think the current system would be capable of working there.
I think that's something we need to pursue. That's, I mean, you're thinking about it and so on, but we've obviously got a time scale in front of us to ensure that there aren't these gaps. I think, unless you have anything further you wish to add, because we've had quite a good session at it, perhaps I would like to just ask to put you in place, Professor Miller, and say that this bill has two parts. And of course, one can't reject one part because you reject the entire bill in its entirety. It would be an amendment that would be, sabotage the civil part as well. So if we have issues, we may have concerns about the operation, what would be a suggestion, the way the committee might handle it if they're so minded, to ensure that this part of the bill proceeds, but taking account of all the, I think a committee would agree, quite serious points that have been raised around by a previous panel and yourselves. How would we resolve it?
Well, I think there's a number of steps you could take to satisfy yourselves that this was good legislation. One would be, I think, there needs to be a more thorough impact assessment done than has been the case so far. There could be a pilot done to test whether this does work, whether the concerns raised are legitimate or ill-founded. There could be a sunset clause provision to be able to evaluate it after a period of time and see what the impact had been. So all of these would be possible. The end topic there about PDSO, it might be good to get some clarity, because Mr Pearson asked the question, and I think I picked it up correctly, that contributions would also have to be made to PDSO by the accused. And my concern is not someone who's trying to manipulate the system, but someone who simply can't afford, who's unable to pay the level of contributions. And having PDSO as a safety net wouldn't be a safety net for that person, and that's my continuing concern.
I wasn't meaning exclusively for somebody manipulating, but in either of the circumstances, just to ensure justice continues. I think that's very useful. Thank you very much, and thank you for your evidence. And we are now going to move into private session.